The Center for Families and Children works to strengthen the family, which we heard a lot about this morning and which we happen to believe is the foundation of a strong and free society. We do this by advancing solutions to increase self-governance within families and within communities in order to support human flourishing. Now, as you can imagine, a significant amount of our work focuses on the child welfare system. Foster care reform has been a banner issue for the Center for Families and Children. But we also go much deeper by identifying and addressing the root causes of family breakup and involvement with the child welfare system. Now, even though my office is right next to David Balot's, I am not a healthcare expert. That does not transfer through the wall via osmosis. So if he asks you, I completely nailed this medical analogy. If we think of the weakening of the family as a disease, then we have to look at the symptoms in order to properly diagnose and treat the patient. The symptom that we're looking at today is the growing number of Texas families who find their rights and duties being litigated in court. As of 2018, nearly 50% of all cases filed in state district courts were family law cases. This includes both private disputes, like custody and divorce, as well as government-driven actions like child protective services cases. And over the last 5 years, the greatest increases in filing have occurred in child protection, which saw a 30% increase in cases filed, child support, a 25% increase, protective orders, 16% increase, and modifications of existing orders, a 14% increase. As more Texas families are finding significant aspects of their lives being managed by court orders, it is imperative that we consider the factors driving this trend and the extent to which public policy is contributing to the patient's illness. I'm honored to be joined today by an incredible panel of experts, each of whom has made a significant impact on the practice of family law and improving the lives of children and families in this state. Texas Supreme Court Justice Jimmy Blacklock was appointed to the court in January 2018 by Governor Greg Abbott. He previously served as Governor Abbott's general counsel in the office of the Attorney General. While at the Attorney General's office, he handled appeals and trials of constitutional cases in state and federal courts involving matters such as federalism, religious liberty, and separation of powers. Earlier in his career, Justice Blacklock was appointed by President George W. Bush to serve in the Civil Rights Division of the U.S. Department of Justice and worked in private practice in Houston and Austin. A Houston native, Justice Blacklock earned his undergraduate degree right here at the University of Texas and his law degree from Yale Law School. He now lives in Austin with his wife and their 3 daughters. Representative Gene Wu has served the people of District 137 in the Texas House since 2012. A proud Houstonian, he's a member of the House Committees on Appropriations and Pensions, Investments, and Financial Services. Prior to his election to the House, Representative Wu served as a prosecutor in the Harris County District Attorney's Office. Since Texas stubbornly holds to this view that public service should be just that, and we pay our elected officials accordingly, many of our members have to have real jobs. So in addition to his very busy legislative schedule, Representative Wu is also an attorney in private practice with a special focus on representing young people and their families. He holds a bachelor's degree of science from Texas A&M University, a master's degree from the LBJ School of Public Policy at the University of Texas, and a law degree from South Texas College of Law in Houston. Representative Wu lives in Houston with his wife and their 2 sons. Holly Draper is an attorney in private practice, serving as managing partner for the Draper Law Firm in McKinney, Texas. A graduate of Texas Tech University and the University of Texas School of Law, Holly is board certified in family law by the Texas Board of Legal Specialization and participates in the family law sections of the Collin County Bar Association and the State Bar of Texas. In her practice, she focuses on a variety of family law issues ranging from divorce to child custody to grandparents' rights and everything in between. In 2019, Holly was recognized as super lawyer in the field of family law, a distinction only 5% of attorneys in the state receive. She's also been recognized as one of the top 50 up-and-coming women lawyers in Texas. Outside of the office, Holly enjoys traveling and spending time with her husband, their 2 children, and 2 very large dogs, from what I can tell. Dennis Slate is also a private practice attorney, serving as managing partner for Slate & Associates in Houston, Texas. He began building his practice shortly after graduating law school and devoted his legal career to handling complex family law cases, including child protective services cases. He's board certified in family law and was one of the first attorneys in Texas to achieve board certification in the newly created child welfare law specialty. Throughout his career, he has received numerous awards, including Super Lawyer, Top Family Lawyer, and Top Young Lawyer in Houston. In addition to his legal career, Dennis invested 25 years into a military career, where he served as a major in the U.S. Army Reserves. He received his undergraduate degree from Texas A&M University and his law degree from the University of Houston Law Center. Dennis currently resides in Pearland, Texas, with his wife and their 2 daughters. Please join me in welcoming our panelists.
Thank you.
So I'd like to start our conversation with what we see as a foundational question that comes up in nearly every family law case in the state of Texas, and that is the rights and duties and the scope of those rights of parents and their children. Now, both Texas and the United States Supreme Court have long recognized that the parent-child relationship is a fundamental right. In fact, Justice Sandra Day O'Connor in the famous Troxell v. Granville case wrote that the interest of parents in the care and custody and control of their children is perhaps the oldest of the fundamental liberty interests recognized by this court. Justice Blacklock, I'd like to start with you. Obviously, these are incredibly difficult cases, and by the time they make it to the Supreme Court, you're dealing with some of the more complex issues that come up in this field. How do you approach these cases involving families that come before the court, especially those that implicate that fundamental right?
Well, first of all, thank you for having me today to talk about this important subject. You mentioned Troxell, which is a very important opinion from the U.S. Supreme Court that talks about the fundamental rights of parents. The Texas Supreme Court has applied that case several different times. In the position I'm in, those issues come before us, those cases come before us. We actually have a case right now that involves some of those legal issues, so I can't talk in too much detail about my thoughts about those issues. You have to read our opinions to know what we think about the law. But what I'll say is that on the Texas Supreme Court, we hear civil cases only. We don't hear criminal cases. So most of what we hear are cases, fights about money, commercial cases, contract disputes, disputes about how the government works, administrative law. We get injury cases, which sometimes have very difficult and sad facts, but ultimately these are all fights about money. And you ask anybody what they value more than money, and there are a few poor wretches who will say nothing, but most everybody will say their family. What's more important to you than money? Most people will say my family. And that's the other category of cases that we hear on the court, family law cases. And I didn't have a background myself in family law. Different justices on the court bring different things to the court. I didn't have a background personally in family law, but I was really struck immediately upon getting to the court about how many of these cases we have and how difficult so many of them are. Most of what we see at the Supreme Court in terms of family law are cases where the rights of parents have been terminated. And parents are appealing that decision up through the courts of appeals up to the Supreme Court. And so the question for the court is it's not money. It's something much deeper and more important. It's whether a family is going to continue to exist. And in so many of these cases, the root problem is drugs. More than half, we get a couple hundred of these cases a year, roughly, where rights have been terminated. And I just haven't looked at the numbers exactly, but I think more than half of the cases involve methamphetamine in particular. Just destroying people's lives and rendering them unable to take care of themselves, much less children. And so in many of these cases, the government has to step in and protect the children, and that's what the law provides for, and the courts are there to make sure that the process is followed, because we have due process rights in liberty, property. Nowhere is the guarantee of due process more important than when the state is trying to interfere in a family's ability a parent's ability to make decisions for their own children and for their family. And so we try as hard as we can in the midst of these very difficult facts and very sad cases to make sure that even for the people who have done terrible things and have treated their children terribly. And the situations where courts and juries have decided that the rights do need to be terminated, our job is to make sure that the guarantees of due process under the Constitution are followed.
Thank you for that. Holly and Dennis, from your perspective as practitioners, how does Texas do at protecting the fundamental rights of children and families?
You want to do family law and I'll do CPS?
Sure. So one of the things Justice Blacklock just mentioned was relating to money, and that families are kind of valued. That's the one thing people value more than money. Unfortunately, in the system that we have today, if you don't have a lot of money, it's really hard to fight for those rights. And with the nature of the appellate system, usually you can't get very far unless you get to a final judgment in your case, which leads to most people not being able to afford, in a really hotly contested case, to get all the way to a judgment and then appeal it. And I think that has a really negative impact on the ability of people to have those rights protected, because they feel like they have no choice but to settle quickly. I think one of the other big right issues that we see relates to parenting time and a presumption of standard possession versus 50-50, and how does child support fall into that? There's not a lot of guidance, there's no guidance at all in the Texas Family Code related to a 50-50 schedule or what happens with child support in that situation. And that has led us to a place where the judge you end up with is the most important thing that happens. And it's luck of the draw, you don't know who you're gonna get. A lot of those judges might not be qualified for family law, they might not be qualified for much of anything other than winning elections. And you know, that can also lead to a lot of problems.
So on the concept of how do we do as in Texas here as far as honoring and protecting family rights, fundamental rights, I think it's taken some bit of time to educate people that essentially what troxel means, and that essentially that's our Supreme Court recognizing that raising your kids is on the same level as owning a gun or having a First Amendment right. And so when the government, you know, in a lot of cases that I deal with, which are CPS related, when the government wants to come in and impinge upon that right of raising your kids in any way, shape, or form, that you have a certain amount of constitutional protection. And I think that, as Holly said, a lot of times it's, you know, what judge are you going to get and what judge understands it. But ultimately, to me, I think the role of the judge is to essentially protect not the child, but to protect the Constitution. The judge is the gatekeeper. The judge's role is to essentially keep the government on one side and people on the other, and essentially decide when the government's allowed to kind of cross through that gate and impede in that family's life. What we had for a long time, we've had a lot of judges who ran and ran in elections and made campaign promises that they would essentially, that if they got elected, that they would protect children. Well, that's CPS's job, not the judge's job. The judge's job is to essentially protect rights, and in doing so, may protect the kids from CPS, may protect the kids from an abusive parent, but one way or another. And so as I would say, we've gotten better, more judges now than when I initially started practicing 19 years ago, honor that as being a fundamental right. I always teach it in CLE classes to other lawyers that that's the argument you have to make. You have to start with the premise and tell everyone, hey, this is a fundamental right, and let's remind everybody it's a fundamental right, and let's make sure that the highest of protections are applied to this case, and that we're not just making, oh, well, let's just maybe let's protect the kid. Oh, let's just wait and see, and we'll just go ahead and put the kid in foster care just for a little while, let's see. That's not good enough. But I think we're getting better. I think that, you know, for years, there have been lobbying groups that supported the CPS side of things as far as making it easier to remove children. It's only in the recent, past, organizations like TPPF that have gotten involved and looked at it from a perspective of, wait just a second, we've slid this thing so far over here to this side of protecting children, and that's a noble cause, and no one is ever going to be able to stand up and say, no, you shouldn't protect children, but they were doing it at the expense of parents' rights. And so now there is some effort and push in education. I think it's gotten better, definitely in like the last 4 or 5 years, since people like Andrew are focused on this all the time to help get it back where it should be. Because where it should be is the judge's job is only to call balls and strikes on the Constitution.
Representative Wu, you've played a leading role in many of these efforts. You passed House Bill 7 back during the 85th legislature, which was a comprehensive child welfare reform package that includes several important protections as well as guidance for how courts implement those protections. Tell us a little bit about why this bill was so important to you, how you've seen it being implemented, and then what family law issues we can expect to see in the next session.
I completely agree with Dennis that the judge's place in these type of cases is to be a judge, to be a neutral arbiter of the process, and to make sure that the law is followed, and to make sure rights are protected. And sort of the way I look at this stuff is that the CPS system is a very finely balanced system, that if you tip it one side a little bit too much, you have parents who lose their rights unnecessarily. And I describe the termination of parental rights as the death penalty of the civil world, because there's no higher penalty on the civil side, because on the civil side it's just money. Like the justice, like I said, it's just, most of it's just money. But outside of the criminal world, on the civil side, the worst thing you can do to a human being on the civil side is take away their children, and that is, there's nothing higher. And so, we try to keep this finely balanced system of, if you tip it too much on one side, you have parents who lose their rights, who are basically, let's just say, executed unnecessarily. And if you tip it too much on the other side, you have dead kids. You have dead children. And we try not to, what I strive to do is try to keep the law right in the middle. And what I've noticed in my practice, and I do CPS cases as an opponent attorney, is like it feels like over time the law and the system created by the law was tipping more and more onto the side of CPS. And and some of the stuff we passed in HB 7 were stuff like, hey, don't terminate parents based on misdemeanor convictions. It just makes no sense. Don't terminate parents because they got busted for pot, right? The stuff that crack, meth, I get it, but it's one of those things where you need to show that the parent actually is incapable of being a parent. And I think a lot of the things that we try to do in HB 7 is just try to tip the scale, just back just a tiny little bit, and to rebalance the system. That being said, I think what I am looking for in the future of CPS legislation is we're going to actually be working on some legislation, and Dennis knows a lot about this, is sort of the medical abuse cases where you have an expert who comes in and just says, this child has been abused, but and there's disagreement about it based on medical expertise. And I've actually been a part of several of those cases, and there's a lot of sense of frustration in dealing with those kind of cases. And we need a better system of how to handle it, because what ultimately happens is you have one expert who comes in and their word is law. And their word, it's a word of God, because they're the only doctor in that courtroom. And some of the stuff that we're trying to do is look, the other side of it is there's no ability to hire other experts who come in and say, no, I looked at the same thing, I disagree. And I think that's important. Again, if we're trying to have a system where it's balanced, you can't have one side just completely over on the other side. Some of the other stuff that we've been trying to work on since HB7 is we want to look at more preventative measures. And what I have been an advocate for, and I know a lot of other people as well, is starting a CPS formal case is a measure of last resort, and I think it really should be. You should not remove a child, and you shouldn't start the process of taking away a parent's rights unless it is the absolute last thing to do. And what we're trying to do is find more funding, find more programs where we help parents do what they need to do and to protect children at the same time without starting the process, without starting them on that road.
And we have a really unique opportunity to do that with the federal government passing the Family First
Correct.
Act, which redirects how federal funds that go toward foster care are able to be spent. So previously, Title 4E of the Social Security Act funds foster care in the states. That could only be used for maintaining a child in foster care. Beginning in October of 2021, states will be allowed to direct those funds toward those prevention efforts. So I know there's going to be a lot of effort that you and your colleagues are undertaking to figure out, okay, how do we do that in Texas when the time comes? Justice Blacklock, you were one day interject.
I just wanted to say one more thing. I talked about how the difference between criminal cases and civil cases, and we only have civil cases at the Supreme Court. You know, the due process protections are greater in criminal cases. You have the beyond a reasonable doubt standard. In civil cases, you have lower evidentiary standards. You have all kinds of other protections that exist in criminal cases that don't generally exist in civil cases. And reflecting on these cases, you know, being part of deciding some of them myself, I have wondered whether that makes sense, frankly, because for me personally, and this is a question that we should all ask ourselves, if you have children, would you rather go to jail for a while, or would you rather have your children taken away from you? And there is no question I would rather go to jail. It's not even close. And does it make sense then, if that's how we feel about the importance of what's at stake here, does it make sense to treat these as civil cases with lower burdens and fewer due process protections? And a lot of that is up to the legislature and up to you know, what's in the family code, and not up to the judges. But it's a question I think we need to think about seriously.
I'd like to circle back a little bit later on to dive into some of those CPS issues that we've been talking about a little deeper. But as I mentioned in my opening, we really have two avenues that we're exploring. It's the private and the public side. So Holly, in the private side, which is where you really specialize, divorce cases, custody disputes, child support. Now, obviously you mentioned the judge you get has a lot to do with what the outcome is, and are you able to hire a quality attorney like yourself? Tell us about some other policy issues that you encounter on a regular basis that make these difficult circumstances even more challenging for families.
There are a few issues that come up that I think, you know, if the goal is to try and keep families out of the courtroom, there's a few things that kind of get in the way of that. When it comes to modifying prior orders, there's an increased burden of going back to court within a year, but it's only if you're trying to switch the primary parent. So anybody else can go back into court right away over and over and over if the primary designation is not the issue in the case. I think having some stricter requirements for change within a year would be a good idea to decrease the amount of litigation going on among families. I also think whereas I do think cases need to be a fact-specific, case-by-case basis, I think there should also be more guidance to judges on what they should do, where it is less based on the particular person you're going to get as your judge and more based upon what the law says should happen in your case, so that will help us as family lawyers help people reach amicable solutions in cases rather than rolling the dice with what a judge is going to do.
One of the things that Holly mentioned earlier was this concept of equal parenting, shared parenting, sometimes called 50-50 possession. Representative Wu, in recent years, there's been a pretty concerted push among some groups, both in Texas and around the country, to move toward this being a default standard in the code. And the legislature has considered, but did not pass, versions of this legislation in 2017 and 2019. Talk a little bit about this concept of equal parenting. why it looks like it's having some trouble getting traction in Texas, and some benefits and drawbacks to putting that in statute.
So I actually had to, when we sent out the questions, I actually had to go look it up. This was not something that popped up on my radar. You know, it's hard for me to say like what it exactly is. Sometimes it's, I'm going to say this in the nicest way possible. Just because somebody files a bill doesn't mean it's like necessarily something that is always the highest priority. Right. So like I filed like 50, 60 bills a session. And you know, some bills we push harder than other bills. And sometimes, you know, for legislation, the honest answer is the system is designed to kill bills. And you may have to work a piece of legislation multiple times, multiple sessions before it goes through. I mean, I can think of at least like a half dozen bills that I have that I've filed for 4 sessions now. And you know, each time we get a little more traction on it. But especially this type of legislation, there's a couple of factors. One thing I want to note, like when I worked on HB 7, right, we had squared away the details long before we filed it, right? We had met with the stakeholders, we had worked out, like, are you okay with this? This is a better wording for you. And we worked it out with all the stakeholders and said, like, okay, everyone's okay? Like, but so when we filed it, you know, when we took it to committee, it was like a 90, 100 page bill that everyone who testified said, yeah, we're basically okay with it, right? And that's the kind of homework you need to do. And with a big change like the equal parenting legislation, I think you really need to go through and you need to talk to judges. You need to have input from various stakeholders, and if everyone's basically okay with it, then it goes through. So for most of CPS legislation, everyone is generally very hesitant to make big changes. Again, you go back to the balance. Or, again, I know it's not CPS legislation, but for childcare, for this kind of stuff, where if you're doing something that is a major change from what has been done since the beginning of time, I think people are very hesitant and say, like, whoa. Are we sure this is the right thing to do? And I think one of the last things that, especially in like, compared to like HB 7, is we try to not do stuff where we tell judges what to do. And I think the equal parenting stuff, I think, like, sort of ties judges' hands more so. And it's just, again, this is me just looking at this. My staff like sent it to me, yesterday in the afternoon. I just briefly looked at it. That would be my comment is I've always, on this kind of stuff, I always try to do legislation that doesn't tie a judge's hands and say you have to do it this way. And I think that maybe those are some of the factors that, you know, if they're going to file this legislation in the future, that they want to look at.
Any other thoughts from the rest of the panel on this concept of equal parenting? Is this something that Texas should look at, should pursue? You obviously mentioned the challenges with how do you do support in those cases?
So we see 50-50 schedules a lot in my practice, and I don't know that there should necessarily be a default that a 50-50 schedule is the appropriate place to start, but I think there should be a default that the parents should be considered on equal footing for parenting as the place to start. And what schedule is appropriate for this particular family is going to depend on what are the parents' jobs, how far apart are they going to live. With 50-50 schedules, it is much easier if the parents are living close together than if they live, one lives in northwest part of the county and one lives in the southeast part of the county. Everybody's going to be miserable. And I think there's this kind of assumption out there that the primary parent is going to be the mother, and that dad's going to have standard possession or expanded standard possession. And I think that's the concept that needs to change, and it maybe is more of a cultural mindset change than anything else. But I've represented plenty of dads who are a lot better than the mother. And it seems like dads have a burden of just trying to get to 50-50, much less flipping it all the way over. So I think putting the parents on equal grounds in terms of where we start is the most important thing.
So just for edification for anyone who doesn't already know, the way Texas, our system is set up is that a judge is supposed to make a call, a decision on who is going to be, quote unquote, the primary, and that's the person who gets to designate where the kids are going to live. All those rights and duties are then supposed to be decided by the judge. At that point, the person that was selected as the primary, the other parent, is then, there's a presumption in our law that says that it's in the best interest of the child for them to have a standard possession order. Standard possession orders are, most people know what they are, but they're like 6 p.m. to Friday to 6 p.m. on a Sunday. Then there's a thing that says that, hey, this parent, if you've been given a standard possession order, if you would like, you may elect to have an expanded standard possession order. Expanded standard possession order is a lot of time. I mean, it's not 50-50, but it's within about 17 to 20 days of a 50-50 a year. So these other states, I went and started looking it up. I actually have a very close friend of mine who's getting a divorce in Arizona right now, and they have a 50-50 automatic law in place. And literally what happens is as soon as you file, it's presumed they're going to get a 50-50, and there's not going to be any child support. And it doesn't, and there are scenarios where, hey, that'd be great, and it's fine, that's what should happen, but there are scenarios where that would be truly detrimental. Texas is a state that isn't real big on alimony, right? We don't have alimony, we have spousal maintenance. The law on spousal maintenance says that we're supposed to make it, you only get it if you've been married 10 years. You're only eligible to get it if you've been married 10 years. You're supposed to squash it. The judge is supposed to squash it down to the lowest amount that meets the minimum reasonable needs. The judge is supposed to make it as short a period of time as possible or as needed to support someone just until they can get kind of up on their feet. We essentially are a bootstrap state. Pick yourself up by your bootstraps. Because of that, the stay-at-home mom who's been married for 9 years who gets divorced would be destroyed under a scenario where you automatically had 50-50 and no child support. What I think would maybe potentially eliminate some of that discussion on fees if Texas were to go that route would be essentially just to make 50-50 a second election. So if the judge makes a conservatorship decision, that person is now the primary, that person then gets to make the decision on where the kids live, also gets to receive child support. The other parent is then presumed to have a standard possession order. They can then elect expanded standard if they can do it, or they can elect a 50-50, and it wouldn't bother or disrupt that ability to receive child support. I think you could do it that way. It's just that you have some of the financials because we don't have alimony, because Arizona is an alimony state, so they kind of make up for what my friend might lose in the child support piece with she can get alimony for a long time. We have to, every time you tilt one thing over here, you can't just say, well, because these other states are doing it, we should do it, because we're a little different. Texas is, there are literally people who move here to get divorced from here because our states have laws, and we don't have alimony, we don't have some of the high child support, we have caps on stuff. But if it was done, I'm a family lawyer like Holly, we're going to end up with just as many cases on one side that's going to love a 50-50 as cases on the other side that aren't. So that part isn't such a big deal. It would be crushing to someone who had stayed at home with the kids for some period of time and then wasn't financially going to receive any money for the 50% of the time that they had the kid, and if the other side's out making $300,000 a year. So I think there should be some things in there, but I think there's probably a way to work it that wouldn't affect the financials, and still, because time, obviously, I'm a father. If my wife decided to leave me tomorrow, I'd love as much time as I could have with my girls. Yeah.
That's a great point. And I think the theme that we're seeing in all of these cases is this is a very finely balanced system that we're working with, and more so than in a lot of other areas of the law. Dennis, you had mentioned a phrase, the best interest of the child. And Justice Blacklock, I want to pose this question to you. This is pointed to in family law cases as the gold standard. We're always trying to make decisions involving children that are in that child's best interest. What does that mean? And for you as a judge trying to apply that from the bench, what thoughts go through your mind? What standards go through your mind when you're looking at a case to say, this is this child's best interest?
Well, what you hope to have with legal standards in general are rules that can be applied predictably by different people with different values, different judgments can apply a legal rule and get to the same place so that the law is predictable, people can know their rights and understand how the courts are likely to handle a case. Those are the best legal rules. And the rule that the courts will enforce the best interests of a child is not a rule like that. It's a rule that's the application of that rule is going to differ based on who the judge is and what the circumstances are, and that's difficult. I mean, Holly mentioned how important it is which judge you're going to get in one of these cases, and how is that person going to think about what the best interests of children are. You know, we have a legal standard, we call it the Holly factors. Comes from a case called Holly that the Texas Supreme Court decided a while back, and it lists several factors that should be considered by courts when they're thinking about what the best interests of a child are. But it's a non-exclusive list of factors, and it's really just a list of things that any person in their right mind would think about when they're trying to decide what a child's best interests are. So I don't know that it's particularly useful, really. I think what happens is that different people make different judgments, and you hope that the right people are in these positions of power to make good judgments about what's best for children. You know, one thing about the Holly factors that you notice, if you look them up and read them, they're focused on the child and avoiding harm to the child, but one of the Holly factors is not a presumption in favor of the parents. The Holly factors don't include the notion that there is inherent harm in breaking up a family, and that's something that I think ought to be thought about, and certainly that as I approach these cases, thinking about best interests, that's something that seems clear to me has to be a part of a best interest calculation.
I want to circle back now to Child Protective Services cases to set the conversation up a little bit. During the 5-year period between 2013 and 2018, as we said earlier, the number of child protection cases in Texas increased by about 30%. And this roughly correlates with the increase in removals during that same time period of children being removed from their families and placed into the custody of the state. So while we did see a slight decrease in removals this last year in 2019, it remains to be seen whether this is a sign that this trend is reversing or if it's just a momentary blip. Representative Wu, just very quickly, in your opinion, what is driving the increase in Child Protective Services cases and specifically removals in the state?
The easier answer is we don't know. Some of it is purely a factor of there's now more money in the system. In the past, because investigation was so underfunded, you know, if you only have a day to deal with one case and you have to move on to the next one after 24 hours, if you can't locate somebody and you're not sure where they are, you just say, screw it, let's just move on to the next one, and you may let a lot of cases go. With the increase in funding for investigations, we actually had discussed this in appropriations, that there is a concern that there will be more removals, more cases, because investigations has more money now, and they have more workers are able to spend more time and be more diligent. And you know, my argument for them is like, that's not necessarily a bad thing, that we're able to be more diligent about our investigations. Now, some of the offset should be, we also kicked more money over to FBSS, which is basically like, I don't know what the best way to describe it is, like just like services before we have to start a case, and hopefully get parents to do what we need to do, get them to do before we have to formally start a case. And some of it is simply our state's growing at a pretty immense rate. So, I mean, we're at what, 30 million people now, and it's growing quite rapidly. So we don't know. There's no way to pinpoint an exact reason, but I think it's a combination of multiple factors.
One of those factors that has been pointed out and that you alluded to is folks raising concerns, including the Policy Foundation, around is there overreach going on? It centers around those due process issues. So I want to throw this out to the whole panel. Do you see that overreach by CPS right now is a problem in Texas causing a pendulum swing? Or what are there other factors in play?
So yeah, Andrew, you remember a couple of years ago they passed a bill that said that CPS was supposed to, if there was two parents living in the home and they were accusing just one of the parents of being the reason for removal, that they had to file and only say basically they wanted to remove that parent from the home. Remember that bill? Yeah. So that bill, it's a law now, it's in the book, and it says that that's what CPS is supposed to do. I have yet, and I've handled at least 100 cases since that thing went on the books, I've yet to see CPS actually plead it and use it. And so they still, to this day, I mean, there's no teeth in the law as far as like a penalty for CPS if they don't do it, but we have this great law that we can all point to and say, hey, look, if only one of the parents is the problem, maybe the one parent used drugs or one parent spanked the kid too hard or did something, CPS is supposed to plead and ask just to remove. They don't. They plead and ask to take the kids away from both parents regardless. And then they just say, oh, well, this parent right here, although they did it, the other one, the other parent didn't really believe that they injured the child or they harmed the child, so therefore they must be a danger too. They never pleaded. So things like that, we have some protections in there, but we don't have, there's no teeth in that law as far as like, oh, if CPS, if you don't plead this, you could have the whole case thrown out. The other thing is that this past legislative session and some of the bills that were pushed didn't make it through. There was the notion of putting it in writing that, hey, there are presumptions in place that family is where these kids need to go and we need to exhaust all family remedies before we take that last step. It got pretty far. I mean, some of those bills got even out of committee and voted, some of them even through the state, through the House of Representatives, and got killed in committees or calendars or whatever they kill them in. That needs to get back on there. That needs to get pushed again. We really have got to make it the adversary hearings in 262, 201, we had some great stuff written up last legislative session, essentially to add these protections and make it so that it was an easy checklist for a judge to go, nope, this, did we look for the relatives? Did we presume that that's the best place for them? Did we make sure that we checked off to see whether or not we need to remove them and put them into foster care? And did we look at aunts and uncles and all those people? No, we didn't, so we're not going to remove them. So put that burden back on there, and hopefully this next, like Gene said, sometimes it's a process to get everyone going. Hopefully this next time we do all of the groundwork and do all the pushing ahead of time and meet with all the stakeholders and we get this stuff put in there, because that will make it back to even. It will give these judges who might have had this other mindset that we're supposed to be protecting children back to the, hey, wait just a second, I'm supposed to protect these fundamental rights. Let's go ahead and list out what the fundamental rights are in the 262, 201, just so it's right there in black and white and easy to argue.
You know, you mentioned overreach by CPS. One thing that I've seen at the court that surprised me, I didn't realize was happening, but you might put it under the category of overreach. Any time that CPS files a case against parents in court, even if it's a situation where it's not that dire, and maybe the most that CPS could reasonably be asking for from the court is some restrictions on the parents, maybe some reporting to CPS or some parenting classes or this sort of thing. Anytime they file a case, no matter how minor the case is, they seem to always plead for termination. So the petition says we want parenting classes, we want monitoring, we want this, we want that, and we also want termination of parental rights forever. And in a normal case, you can't plead things in your petition that you don't have a good faith basis for. But they plead termination every time, and then what happens naturally, as you can imagine, is that the parents get that petition and it says, we want to take your children away. And that has an enormous impact on the way everything progresses and the way that the parents are able to negotiate with the state and hire a lawyer and go through the whole process. If you have termination forever of your parental rights hanging over your head, even when this is not one of those sort of methamphetamine addiction cases that I was talking about. It's a much more minor case. There's an imbalance there in the power between the two sides and the ability to negotiate fairly over what's happening. And I've not seen a case at the court yet where that particular issue has come up. I've just noticed that termination is asked for in all these petitions, and I wonder whether there's any justification for that.
If I could tail in on Justice's comment, he's right, and we have this rule in the Rules of Civil Procedure, Rule 13, that says that if you make a pleading and you didn't do some reasonable investigation that the facts that you're about to allege are true, you can be sanctioned for it. But CPS has for years thrown in termination pleadings, and they'll just list all 20-something termination grounds against a parent, and just later on we'll develop and see what it is. Well, if we were in the civil world in civil court and someone just started making up stuff about you in a pleading, you'd get to sanction them. And yet sometimes when I bring these sanction cases on that same issue, judges go, oh, that's just CPS. They're allowed to plead whatever they want. And I don't see anywhere in the Rules of Civil Procedure where the Supreme Court has basically said, these rules apply to everyone except CPS. So I agree with it. We need to hold everyone who is a civil litigant to the same standard.
I mean, the answer to overreaching CPS is you're supposed to have judges who check that, ideally. And one of the things that we did in HB 7 was we asked the Supreme Court to see if it's good, if it's reasonable to delineate the termination grounds. Because in the past, you would just have, if you go to the jury with it, it was just a one question: should you terminate, yes or no? And CPS pleads all of these different grounds, and I think the jury's just like, sure, why not? And I think that's a big problem. And so now the Supreme Court just issued an order saying they're going to start the rulemaking process. The advisory committee said that this is a good idea. And so hopefully we will have delineated termination grounds, individual termination grounds, saying like, what is it, A through W now, and I can't remember. We keep adding more each time.
I think we might be to AA now.
Yeah. And so, hopefully that will be at least a little bit of a blockade to CPS, just willy-nilly, just throwing everything in the kitchen sink, saying like, look, if you can't, at trial, you will need to prove up this specific termination ground. You can't just say, well, we should just terminate.
And just to follow up on that, they did issue it on January 8th, and I'm on the patent jury committee. We took it, and we are already drafting it. It should go out in the next book.
Very excited. I'm very excited. That's going to be a game changer.
That's huge. Absolutely. Before we move on from this topic, in October, the Supreme Court issued a stay in a case that made headlines across the state, which the foundation filed an amicus brief in on behalf of several members of the legislature. This is the Pardo case. And in that emergency stay, the court ordered the immediate return of the child to his family following a removal for what we argued and what in our opinion was a very tenuous at best foundation. Justice Blacklock, I'm going to ask the bold question since the case is over and closed and the family's back together. That's a really difficult call to make as a judge of whether or not to return a child to their family. If you do it right, it's the right call, everybody's fine. But if you do it wrong and something bad happens to the child, that's living in the back of your mind. Could you talk a little bit, and I don't know if you can specifically address the thinking in Pardo, but even in more general terms about when you have to make that call as a judge, how do you go through that thought process?
Well, I'll talk about that case. That case is over with, and we have a lot of very difficult cases at the court. We have a lot of cases where the law is unclear, the case is difficult, and you've got to cast a vote one way or another, and you're not sure. Ultimately, you've got to go home and live with the vote you took, but the other side may have some good points. The Pardo case was one where I knew exactly what the right answer was, and I'm glad the court did what it did, because the government had not, on the record that was presented to the court, the government had not satisfied the statutory standards for taking the child away and for keeping the child away while the litigation progresses. And it was clear on the record before us that standard had not been met. And so the court ordered the child returned to his family as the litigation progressed, and then the case ended. The state essentially gave up the case and allowed the child to return to his family. One other point about that case is that it was troubling is that, of course, the family argued, one of the things you have to show to get the kind of stay, we called it a stay, an immediate action, an injunction from the Supreme Court, is that there's imminent harm that's going to happen if the court does not act quickly. And of course, the family argued that our child has been taken from us, and that is harm in itself. The government argued that, well, you haven't shown that the child is being harmed in our possession, and so you haven't shown harm. The government did not agree that taking the child away unjustly is itself imminent harm. And that was striking for me. And certainly the court, based on the action it took, the court had to find, before taking that action, that there was imminent harm. And so the court agreed with the family on that point.
Well, we have a few minutes for Q&A, but before we jump into Q&A, please join me again in thanking our panel for their time. We have a microphone coming around. If you have a question, please raise your hand. And at the Policy Foundation, we like to enforce a very strict rule that a question ends in a question mark. Right here in the front.
I'd like to address this question to Representative Wu. You mentioned earlier in a number of these cases there's only one expert. And of course that's what the appellate judges are looking at, is just the case with the one expert. And you said, hey, if we have a second expert, that would be very helpful. How would you pay for this second expert?
The legislature. And that's actually exactly what we're looking at. So what I've proposed is creating a fund where courts could tap into it. And in these cases, the medical cases are relatively rare. They make up a very small percentage of the CPS cases. And I think, there's some stuff that's very clear cut. I mean, I'm on a case right now where, it's very clearly a shaken baby case. The child is brain damaged and likely will never be a fully functional human being ever again. And no one's really contesting. No one's contesting the medical expertise. But I've also been a part of cases where, it's about a hairline fracture on the arm of a child, and one side says no, this is a standard. This child is just learning to walk, and the child fell down. The other side says no, this is very clearly abuse, and unfortunately, the state has far more resources than a parent can have. Even a court appointed, the court has limited ability to help an indigent parent, and most of the cases that we get, the parents are indigent. I mean, let's just be honest about that. And you say like, well, we need somebody to review 6,000 pages of medical records before we go to our show cause. And the court, you say like, well, we need to pay somebody $10,000 to do that. The court's going to choke on that. But I think if the state created a fund where on these rare cases that they could tap into a fund to help pay for some of the stuff and mitigate the cost of it, I think that would be positive.
And to add a little more context to that, there is already a grant fund that funds the expert for CPS. It's called the MedCares grant program. So the state is already paying for CPS to have their medical expert. So I'm not sure if you're thinking about looking at the way MedCares is structured or...
We also did a bunch of research into their funding recently in a series that got published in NBC and the Houston Chronicle. And they get not only a national grant, but they have a state grant too. Millions and millions of dollars get put into this grant. What the proposal was before is to essentially say, hey, CPS, you can go to one of these doctors and get your initial, hey, here's the problem, and use it to file your case, but all future testimony will have to come from a separate doctor, someone who's not under your same umbrella, to make sure that the two doctors have the same opinion. So it's essentially making CPS use a second opinion. Those same funds and grant money can be used to pay for those same doctors. There's millions of dollars being put into that deal from national and state.
That's reasonable solution.
Have right over here, and then where's our mic there?
Thank you. I do have a question, but first I'd like to commend the panel for what you've said here today. A lot of people are not aware of what you've talked about. And you, Representative Wu, I know you and I would not necessarily find ourselves always on the same side of an issue, but I have to say, I agree with everything you had to say, and I appreciate your work in there. And I look
You're gonna get us both in trouble.
Yeah, I know. That's okay. I stay in so much trouble. I wouldn't know what to do if I was someplace else in there. And the issues you brought up about the termination going forward, that is something definitely we have to address. And also the ability of CPS to outright lie in their court documents and never be held accountable for it.
Yeah.
And we had that in the Pardo case. Matter of fact, that was so egregious, there was nothing in that case that was right. And my question that I'm getting to is, it was so egregious and such a good classic classroom example of CPS gone wild, of an organization that has no rules and doesn't follow them, and they did it throughout that one. My question is, why did the Supreme Court not go ahead and issue a ruling that would have at least put a stumbling block out there? I was delighted for Drake to go home. That was great. But by not following that up and really slapping CPS the way they should have been slapped, we leave hundreds of kids in danger of the same thing happening, of a child being taken with absolutely no rationale behind doing it and no consideration of the trauma of separating the child. So my question is, why did you not go ahead and issue something that would have helped the rest of the state, not just the Pardo child?
Well, it's a perfectly fair question, and I appreciate the feedback. I can't talk about why the court made the decision it made internally. Our deliberations are confidential on why we act the way we act. Maybe many years from now, over a beer, we can discuss it, but probably not even then. The court thinks hard about every case, works as hard as we can to decide every case correctly. We have to act as a group. We cannot act as individuals. There's nothing I can do alone. I need 4 judges with me to do anything. And that's true of all of us. And so we act together, we deliberate together, we think through how can we get 5 votes to do something, and we act accordingly. And we're not able to discuss publicly why those actions were taken.
I'll answer a little bit about it because I studied the Pardo case, but one, the question wasn't really presented to them to do the sanction. That wasn't an issue brought to them to do. 2, they can only answer what they're supposed to. I'll tell you, I routinely like to try and sanction CPS. I have sanctioned CPS several times. I've sanctioned them last fall for $127,000 for essentially stealing the Bright family's children and lying about it. And a caseworker actually got on the witness stand and took the fifth when we started asking him questions about why he was lying about it. And CPS, I crossed my fingers and hoped after we got the sanction, they threatened to appeal it. They filed a notice of appeal. They started requesting records. They got all the way ready and then realized that, gosh, they were going to make some really bad law for themselves. And we just hoped they would appeal, hoped they would, because had they, we could have started the process of basically making it easy to hold them accountable because of the findings that Judge Mike Schneider had made in that case. But they ultimately decided that they didn't want to set a bunch of laws. If we could raise a case up there and get it up to the Supreme Court, let the Supreme Court, sprinkle the fairy dust of sanctions on them, then it would all go across the state. But it's going to take CPS actually. I've sanctioned them once for $35,000, once for $30,000, and once for $127,000, and every time they don't appeal it because they realize they do not want that to go. And essentially make it easy for the rest of everyone else to get them. So they're real careful about that. They just pay the sanction.
And I want to add one thing. So last session, I carried a bill to say CPS caseworkers cannot go back into their into impact and retroactively change things in the reporting system. So it said, like, if you need to make a correction, you make a note below whatever you wrote and say, hey, by the way, I meant to write this, instead of going back and changing it. And really all it would have taken is for IT to go and change permissions for all its users, saying users of this class cannot edit, right? So all caseworkers cannot edit. CPS killed the bill by slapping a $2.8 million fiscal note on it, right? So they asked them, what is this going to cost to implement? And they said $2.8 million. And we need to hire 4 IT people to do it. And this is something like that I think everyone agreed on. It came out of the House with flying colors. Just saying like, hey, you can't go back and edit stuff. Like if you've made a mistake, you just note later on, hey, I made a mistake here, and this is what it actually needs to be. And if you need to make a substantive change, then you have a supervisor do it. And so at least there's one more person that checks it. But they kill. We got it out of the House, and they killed it in the Senate because they slapped a $2.8 million fiscal note on it.
One of the precursors to Representative Wu bringing that bill was in the Bright case. They had they had put entries into their impact system, and then while they were down there filling out the affidavit, we time tracked it. We could see on the time track where they what time they were making changes to it. We could see while they were down in the county attorney's office filling out their sworn affidavit, they were back editing entries that happened a month or 2 months before. We just didn't know we couldn't tell what the edit entries were because CPS turned that mechanism off. We had their IT person come in and testify that, oh, we have the ability to do that, but we turned it off. We turned that system off. So there's no way to stop them from editing their own database right now, and there's no way to go back and essentially go back and look at a redline copy of what they put in their database to see what they changed. So they have the ability, once you call them on something, to go back and fix their own database to match what they're saying now. And we killed that bill.
We've got in the back and then right here in the middle next.
I'd like to go back to the question of custody for fathers. The state retains a percentage of child support monies collected. Is that correct?
Yes. No, there's a fee, I think, to maintain the state disbursement unit, but they don't keep any of the actual child support money. There's a fee that gets tagged.
A fee gets tagged on that's paid for by the child support.
When you set up your account, you have to pay a fee.
Right. Is there some resistance to changing the custody to give fathers more custody due to some financial considerations in collection of child support?
I've never heard that. I just heard the concept of cutting child support out completely and essentially hurting certain people. I've never heard the fee part.
And I'm not an expert in this area, so I mainly deal with CPS.
My understanding is there's some financial considerations, so that's why I was curious about that question. And then considering financial consideration, is there some to CPS for terminating rights? In other words, why do you think is it a cultural thing that there's such a push for terminating rights, or?
I've heard that there is money out there, for like some money that they get more of, but I've never actually felt that one of my cases was being terminated for money. I mean, I'm not saying it doesn't happen. I haven't felt it.
I would think more of it is the 12-month time limit that we put on these cases, where once you file for removal in a CPS case, you've got 12 months to either reunify that child with their parents or terminate rights and move for adoption. The intent there is good because we want kids to have stability, we want them to have permanency. I think when we talk about unintended consequences, part of that, and I would love to hear if you all agree, is that 12-month timeline puts a little bit of pressure on CPS to go ahead and say, well, let's plead the kitchen sink and let's go ahead and say we're going for termination so we can save time later on.
But that timeline doesn't run until they actually put the termination pleading in place. They could plead lower than termination and not have that clock run.
Right here in the middle.
I think that there is a certain sense of we do it this way because this is the way we've always done it. Mm-hmm.
So my question is to you, Representative Wu, and then also to Ms. Draper. So Representative Wu, with your legislation, this is kind of a two-part question. Did you get involved in or sort of look at mandating parenting skills classes for parents before they're put into sort of on a scale basis, whether or not the family, it might be possible? And then what's the what's the structure now, and is that even something that's feasible? Because my concern is that you say you don't want to try to force judges to do things, but it's not really about the judge taking these classes. It's about these parents that are already parents.
So I think the intent of the legislature, and I don't want to speak for the entire body, but what we did in like HB 7 and stuff and other bills is there is a clear intent by the legislature that we don't want children removed if at all possible. I think the body believes that there is harm. We clearly believe that there is harm to a child upon removal. And that's why we pushed more money, a lot more money into like family-based social services and other programs that try to help the parents get training, get the support they need without going towards removal. And we have this a lot on drug cases, where mom tested positive for crack, for cocaine, but we say, like, look, this child is in good condition, child is not harmed, but if we can help this parent overcome their addiction, then that's all we would really need. We're not going to start a case. We're not going to start a case on it, but unfortunately, addiction is hell, and a lot of parents don't get their shit together until the termination case is filed, right? And we've done FBSS, we've done petition for services, and the parents just are like, yeah, whatever. Until we're taking your kids, then they say, oh, whoa. Then they take it seriously.
My understanding or I've heard that CPS is almost in effect rewarded for taking these kids away financially. There's a plus gain in their funding, dependent upon how many kids how does that work that would cause them to push for taking those kids away versus working with the parents to heal the situation within the home?
So I can only speak from my personal experience. I'm mostly ad litem, so mostly I represent the kids, I don't represent the parents. And so just in my experience, and again, this is all anecdotal, is that by the time they're taking the kids away, especially if it's a case where it's kind of borderline, this is like CPS's third, fourth, or fifth attempt to try to get the parents to comply. And there's just no compliance. That's my experience. There is some, CPS gets money based on how many kids are in their care. That's just, you don't just give them a giant wad of money. They said basically, you get money for the amount of kids in your care. But, I don't think CPS is doing this to get money. I think they would much rather not have to deal with those kids because I don't think, no one's making money on this. At least I don't see it that way.
And some of that could be a function of the way Title IV-E has been structured versus the direction that it's going. With Families First, you're moving more towards an outcomes-based. 4E, the way that it's currently structured, is you're paid based on the kids in foster care, so I think that can be interpreted sometimes. But it's more a function of a mechanism rather than an incentive from my perspective. We're very tight on time, and there's two people who have been waiting very patiently, so they're in the back and then right over here on the side. We're tight on time, so very quickly, so the folks who have been waiting.
Used to before they put it in the code. Used to happen. Now, it gets brought up now. I've had several cases where they've brought it up, and the code says that they're not allowed to use it as a removal decision, but it still has been getting, the code didn't put in the code to say it's not relevant evidence, so they still bring it in as relevant evidence. The judges just say, well, I didn't use it as the basis to remove, but they can't use it. The CPS can't literally get there and testify and say, oh, you should remove because of it. So they can't because of that provision, but they still talk about it. They're not supposed to talk about homeschool, and they still talk about that too.
And the last question.
I've heard a lot about money, which is all about, it's really important that we spend our money wisely. I'm a CASA volunteer, was on the CASA board. An attempt to ameliorate some of the expenditures that might otherwise be spent by some professional. Does the panel and TPPF also think that kind of methodology of volunteers, does that add value? And is there anything that CASA can do better? An easy question, a hard answer.
I think Dennis has very different opinions about CASA. I like CASA. It's an extra set of eyes. I mean, for me, because I represent the kids. It's an extra set of eyes for us, and it's an extra advocate to go out to do things. I've had very good CASA volunteers. I've had some not so great CASA volunteers. So I'm, as a legislator and as an ad litem, I'm very appreciative. You go for it.
So, okay, so CASA, they're volunteers, right? They're not taking full caseloads of stuff, so they have very limited experience. They haven't done very many of them, and every single case shocks them. And so when they're shocked, then they kind of make like and they're the guardian ad litem for the child, meaning they get to represent the best interest of the child. And so when they're shocked at every single thing that goes on, then they just want to protect kids, and then that means, I have more CASAs go out and recommend removing and keeping from parents, and CASA's the last person ever to get in line. I've got CPS, we're ready to return, but CASA won't agree. So I think the idea behind CASA is great. I love volunteers. I love people who want to get involved, but giving people who are essentially over and over again shocked by what's going on, it can just be minor stuff. The authority of a guardian ad litem is really hard. I mean, it's I'm sure there's some good CASAs.
At TPPF, we work closely with CASA. We may not see eye to eye on every single issue, but that's okay. We have a good working relationship because we acknowledge that we're all in this for the same reason. We want what's best for kids. We want what's best for kids and their families. And in that environment, I think even where you disagree about some details, you are able to develop a good collaborative working relationship, which is essential.
The one thing I would add is I think CASA should prioritize being on cases with older kids who have their own opinions about what they want, and that may differ from, again, that's the whole point of having guardian ad litem, is that, me as the attorney ad litem, what I want to do may be different from what the kids want to do, and that's the whole point of having CASA. And like, CASA doesn't need to be on baby cases. Like, you just don't. But they always insist on being on the baby cases. I'm like, well, what are you doing here? The kid can't talk to you. So, yeah, I mean, if I had a recommendations, like, stop being on baby cases, prioritize the older kids who actually have opinions about what they want and what they want to do.
Thank you all for joining us, and we hope you enjoy the rest of policy orientation.